Before we get started, I just want to put on the record, as I told Mr. Hardman, and I told Mr. Croswell, Mr. Manger, I've known you a long time. I think a lot of you and your family. I want to put that on the record. That's not going to influence what happens here, but I want to make sure, Mr. Manger, that you're comfortable with this court hearing your case.
I am, Your Honor.
All right, and Mr. Hardman, I pointed that out as well, and I want to make sure that your office and you are comfortable with the court hearing this case.
You have mentioned that to me, Your Honor, and it is. We are perfectly comfortable with the court hearing this case.
Thank you. The other thing is I want to point out, just for transparency purposes, my former spouse worked for Mr. Croswell about 15 or 20 years in the Claremont County Commission. Obviously, she thinks a lot of you. As a matter of fact, you just took my kids to lunch. You've known them a long time. They like you, and you guys usually meet yearly and have dinner or lunch. And actually, that just took place less than a week ago because my kids are going to be off, one to college and one to work in another city in Ohio. Is that accurate, Mr. Croswell?
It is, Your Honor.
Does any of that, Mr. Manger, concern you about whether the court continues to hear this case? On the record, 2019 CR 0631, State versus Pat Manger. Mr. Croswell from Mr. Manger. Mr. Manger is present. Mr. Hardman is the special prosecutor in this matter. Mr. Croswell, is there anything you want to add or subtract from the pre-sentence investigation?
Your Honor, the pre-sentence investigation is accurate. And so there's nothing necessary to add to the pre-sentence investigation, but in my remarks concerning sentencing, I will add some pertinent, pertinent facts. Your Honor, the pre-sentence investigation is accurate. It clearly shows that, frankly, that my client has led an exemplary life. He has been, in my mind, even notwithstanding the fact that he's here today, he's been an excellent public servant. He is a husband. He is a father. He's a brother, he's a sister, and he has been loyal to his entire family. The charges which he stands before you on today are misdemeanors. He has no prior criminal history of any type whatsoever, and he has suffered at this point a very significant penalty. Granted, not a legal penalty from the court, but he has suffered a very serious series of penalties as a result of the mistakes he made here. The first thing that's happened is he has resigned as county engineer. So at this point, as he stands here today, he's unemployed, and he's in the process of getting employment, but as he stands here today, he's unemployment. When he entered this plea, he not only resigned as county engineer, but he also entered a plea which prohibits him from having any type of public employment in the state of Ohio for the next 7 years. And something that I didn't know until a few years ago is how much work from an engineering standpoint is done in the public sector. That the county engineers are actually big businesses, and engineers, that's one place that they look for employment, and now that has been precluded. I would tell you that he has applied for several jobs, and on each occasion the folks indicated that they would hire him. These are private contractors, that they would hire him without hesitation, but for the fact that he will have a conviction and that it impacts their corporate bylaws, and that it impacts their bondability and so on and so forth. So, number one, he's lost his job. Number two, he's put himself in a position where his future employment, certainly in the public sector, has been eliminated. In addition to that, as a public official, he had a certain time in service and was a year short of his pension vesting 100%. And in addition to that, in his retirement, he lost the ability to have the medical benefits that he had earned over the past 29 years. So he has, in order to vest his pension, it cost over $80,000 to buy the short period of time that he needed to vest the pension, and he's lost the medical benefits. Your Honor, I think that pales in comparison to the embarrassment and the humiliation that Pat has suffered here. He is not in any way, shape, or form trying to walk away from what occurred here. He's not making excuses for it, nor is he blaming anyone. And by entering his plea, he's acknowledged that he, in fact, has violated a criminal offense. But I think it's only fair to review exactly what it is he pled guilty to. He's pled guilty to receiving improper or additional compensation as a public official, and that public compensation was that he stored some lawn furniture in a public building, and that he made some campaign signs using a campaign computer, or pardon me, county computer and county machinery. What he's not charged with is trying to take kickbacks or trying to personally benefit, I mean, the whole litany of things that go on. He did not do any of those things. In my opinion, and please, I want to make sure I make this clear. This is my opinion. I'm not being critical of anyone. But I pitched repeatedly and continually to the special prosecutor who had an obligation to a client, the state of Ohio, and the auditor. But I pitched repeatedly and continually that the appropriate way to handle this would have been to have my client resign, for there to be a public finding by the auditor, for him to pay restitution and make a written apology to the taxpayers of Claremont County for the mistakes that he made. Now, I understand. I want to make it clear. I'm not being critical of the prosecutor when I say that. I'm saying that I personally felt that would be a fair resolution, but I understand that we all have our own masters, and the special prosecutor in this case was representing the state auditor who clearly had a difference of opinion with me, which is not uncommon. It happens. But that was what I thought would be a fair resolution, and the reason I pitched that was to try to protect his employability, try to protect his pension, and try to protect his medical benefits. That said, if asked, Pat would tell you that he has no one to blame but himself for being here, that he was certainly used bad judgment as a public official, and I think did not understand the potential ramifications of anything that could be considered to be self-dealing or self-help. So with that said, Your Honor, I'm not going to speak to what I think the sentence should be. That clearly is up to you, but I just do want you to know that Pat has suffered greatly. Perhaps to a good man, the embarrassment and humiliation in front of his friends, in front of his family, is maybe even more punishment than the rest of it. I would say to you, in fairness to Pat, hundreds and hundreds of people have reached out to him to offer support and to indicate to him that based upon the person they know, they still think he is a good man, a good friend, and someone that they want to continue to have relationships with, both personally and professionally. This is one of those things that it's a shame that it happened, but it happened, and Pat's here to accept whatever the judgment of the court is.
Thank you. Mr. Manger, anything?
Yes, Your Honor. I just want to say that I'm profoundly sorry for the situation that I put myself in. I realize that the actions that I did put me here. I'm owning up to that responsibility, and I hope that you consider all those things.
Thank you. Mr. Herdman, State?
Your Honor, I think we sufficiently stated the facts under which this plea was entered at the time of the plea. There are obviously statutory mandated penalties for this offense, which is the 7-year ban from public employment. Any penalty, fine, or jail, otherwise that the court deems appropriate, we leave to this court's able discretion.
Thank you. Just a couple things before I forget. Letters, just so you know, they're in the file, came from a lot of genuine people that think a lot about you and your family. Those are in the file for the record. I'm going to point that out. Secondly, some of the letters are asking and pleading with the court, Mr. Manger, that I do something about the 7-year disqualification. I know you know, and I think your family knows, I have no control over that. That's the statute. There's nothing that I could do if I wanted. That's just part of what you entered the plea to. So just so they're aware, there's no discretion in that. And I know you're aware of that. Personally, I'm not supposed to be personal, but personally, I'm super sad for you and your family. Personally, I've known you for a long time, and I told you that before I took the plea, and I told Mr. Hardman's office that. I've been doing this a long time, and I'm really, people pick on me because they think I'm emotionless. I got a job to do. For you and your family, this is more difficult for me than some of the things that some of the horrible things that I've seen throughout my legal career here in Common Pleas, because I know you and your family, at least you and your wife, to be good people. I know you have kids. I know you have people that support you. And so from that standpoint, I couldn't be sadder for you and your family. The other flip side to that is you made some decisions, and you owned up to it. Unfortunately, in this business and in these businesses, we all have what I call a little bit of the greed virus. Sometimes we lose sight of what we're doing and why we're doing it, and we have to catch ourselves. And in this case, it got the best of you. You've had an honest moment in this case by taking full responsibility for your choices, and that certainly doesn't go unnoticed. In imposing a proper sentence, the court is not required to leave its common sense at the door. It must not only rely on legal responsibility, but the court also has to rely on its conscience. I've looked over the pre-sentence investigative report that Mr. Croswell and Mr. Hardman had copies of. You've lived an exemplary life, and the court knows and believes and knows that deep down you're a good person, and you got a little complacent or indifferent about some of the choices you made, and you're here today. When the court thinks about an appropriate sentence for misdemeanors, it has to consider 29, 29, 21, and 22. And when the court considers whether there's a jail sentence, whether there's probation, it has to consider all the totality of the circumstances that got you here, but also the fact that you took complete accountability for it, that you've lived an exemplary life, and that you just made some choices that I think you said you've regretted, and I know you regret. I want to note, before I forget, that there's restitution of $3,000, Mr. Croswell. Is that correct, Mr. Hardman?
That is correct.
And that $3,000 is in your trust account, correct?
It is, Your Honor, and I apologize for not bringing a check this morning. I was originally scheduled to be in municipal court at 2 o'clock today, and yesterday at 5 o'clock they called me and said I'd come at 8:30. So I came directly to Batavia instead of going to my office. The check is actually in Pat's file in my office. I just didn't pick it up. But what I will do, I'm going to be back in my office about 1 o'clock today, and I will put a check in the mail to the Claremont County Clerk of Courts for $3,000 and note that it's restitution in this case.
All right. The struggle here, Mr. Manger, is not to leave the impression that choices for people like us, that it's okay to make bad decisions. It's not. But the other side of it is deterrence is an example for others, but the court doesn't plan on making an example of you. You've made an example of yourself, unfortunately, after all these years of the dedication and loyalty you provided to this county, and just like that, unfortunately, it goes up in smoke because of some choices. What the court is going to order in this matter, after considering the purposes and principles of misdemeanor sentencing under 29, 29, 21, and 29, 29, 22, is, and let me say before I get to that probation is an act of grace, and it's an act for people who the court thinks needs to be rehabilitated. The court doesn't believe that you need to be rehabilitated. As Mr. Croswell pointed out, I think I consider you, and I'm not calling you a name, a normal, ordinary, responsible person who just let this get out of hand and now you're paying for it. So I don't think probation is appropriate either. At this point, the court is not going to order any type of jail sentence. The court is not going to order any condition or term of probation or community control. The court is, and I've talked to Mr. Croswell about this, the court was going to order a fine, but Mr. Croswell is okay if I order you to make a donation of $250 in lieu of the fine to the Literacy Council of Claremont County. I'm not on their board, I'm not connected, I just know they do good work, and I know that they can sometimes use funds to help people become literate. And so, Mr. Croswell, you indicated if I were going to order it as a fine, you wouldn't oppose it if I just ordered it as a donation, correct?
Your Honor, actually, I indicated that would be my preference because I agree with your position that it could do more good at the Literacy Council than just simply rifle through government.
And the state has no objection, correct, Mr. Hardman?
No, Your Honor.
All right, $250 to the Literacy Council of Claremont County. You'll be ordered to pay costs. That's it, Mr. Manger. I hope you're able to get past this, you and your family, and I wish you the best.
Thank you.
All right. Anything else, Mr. Croswell?
No, thank you, sir.
Anything, Mr. Hardman?
I know we discussed restitution, but obviously that's part of the...
$3,000, and I'll put that in the entry, and the court's also going to put on a separate order today without the entry that indicates that the clerk is to accept the $3,000 from your trust account once you send it in. And as an officer of the court, you'll send it in, correct?
I will send it in, but it'll be in the mail at 1 o'clock today.
All right, very good. Thank you.
Thank you, Jake,
All
very
right.
much.
Thank you.